Dolman Russo LLP welcomes you to this Suboxone Town Hall. Please know, this is a live public event. Participation does not create an attorney-client relationship, and it does not establish attorney-client privilege. The information discussed here is for general informational purposes only, and should not be considered legal advice. Please do not share sensitive or personal health information in the live chat. Questions related to individual health conditions or unrelated personal legal matters will not be answered due to privacy concerns. This event is being live streamed and recorded, subject to our privacy policy, which is linked in the video description. The recording may be publicly available after the event. If you do not wish for your name, username, or profile image, which may appear next to your username depending on your Google account settings, to be associated with this video in perpetuity without further compensation or review, please do not participate in the live chat or comment section, as these are publicly visible and may appear in the recording. This event will be starting soon. Thank you.
Hey guys, thanks for logging on to our April Suboxone Town Hall. Once again, I want to reiterate what an honor it is to represent you guys, and we're going to bring you up to speed a little bit today on what's happened since the last time we spoke. You probably recognize Anthony's my cohort in crime, also representing you guys in this case. We're missing Matt today because he's got a conflict, so going to be stuck with just the two of us. So Anthony, it's kind of almost, I'd say, a slow news month in that, you know, when we're giving you updates on what's happened, we're in the discovery process, right? We're getting documents from the other side. We're getting all this information. But just like last week or last month when we talked, all these documents are covered by confidentiality agreements, so we can't really tell you what's in them. So all I can tell you is we're finding out lots of stuff, but I cannot tell you what stuff we're finding out. So most of what's happening in the litigation itself is confidential, so we can't tell you what's going on. But I know we do have a little bit of news we do want to share with you as far as some timing, maybe on bellwethers or something like that. And I think Anthony may want to share some of that.
Yeah, as far as the bellwethers are concerned, we spoke with the committee that's in charge of the discovery and pushing the case forward, and they've informed us that the bellwethers will probably start somewhere in 2027, more toward the later third quarter or fall of next year. So we're looking at about another year and a little bit of change before we get to the first bellwether, and hopefully they'll stagger them quickly, and we'll be able to get through a whole bunch of them and get some values put on these cases.
So, and really, most of you on here has had some horrible stuff happen to you as a result of taking Suboxone, but When it boils down to it, the only thing we can do is get you money, right? That's it. That's why you've got us as an attorney, to make you financially whole for what happened. The bellwether trials are that first little peek behind the curtain at what a jury is likely to do with these cases. So this is when we select cases as plaintiffs, defense selects cases as defense. So the defense selects cases they think, quite frankly, stink and they think they can win. We try to grab cases we think we can win, but all these cases should be representative of different issues in the litigation. What the jury does with these cases is a very good indicator of what they may be worth, and is really the first step we take towards valuing these things for global settlements overall. If you've been watching the news lately, you've seen some bellwether trials go across for like Uber rideshare sex assault claims. That was in the news. Social media addiction. Those bellwethers are going forward. We expect ours sometime fall of 2027. So in the meantime, what can you do, right? You as our clients, your only job right now is pay attention, right? Pay attention, because if we reach out to you, we need something. And sometimes during the case, we can need something and you can get back to us at your own leisure. It may take a month. Started to shift a little bit, though, in this case. So, Anthony, maybe talk a little bit about if we're reaching out on census obligations, or the defense has noticed a deficiency in a census and we're reaching out to you. Anthony, maybe tell them a little bit why it's so important to get back to us quickly.
Yes, one of the main points, and we want to really emphasize in this particular meeting, is that the most important thing going on right now is the censuses. There are some deficiencies coming up. We're going to be notified of those deficiencies. We have 30 days to cure those deficiencies. So we need you to get back to us as soon as possible. Even more importantly is that by the time we research what the deficiency is, once we receive it, we may, have to end up using 10 or 15 days of those 30 to research what it is exactly we need from you. That would leave us with probably, 2 weeks or less in which you have to get that information back to us. It's very important that you check your emails, your phone calls, your faxes, everything, to make sure that you are in touch with us. If anything changes, we need to know updated information on you. It is vital, because if we do not fill out these deficiencies and correct them, your case can be and will likely be discharged, and you'll lose out on the case. So it may be as short as 10 to 14 days left on the deficiency time by the time we get in touch with you. So please make sure you're paying attention and keeping that information on and getting it back to us as quick as possible, because this is vital to your case at this point. It's the most important thing we're probably going to talk about tonight. If you remember anything we're talking about tonight, please remember that if we do reach out to you for the census deficiency corrections.
Yeah, and I will tell you, earlier in the litigation, the judge seemed to be a little bit more forgiving. Let's say when people might miss deadlines by a day or two, where we could say busy at work, these kind of things. During this last last set of hearings we had, there were, I want to say 45 people looking for waivers when they didn't comply with their census timely. I think the only people who got them were people who were incarcerated, or I believe one person was hospitalized in a coma. So things like that would give you an excuse. Other than that, it has to be in on time. Now, here's one thing I say. There's been a comment, I guess, shot across that the longer it takes to try, the more money we make. That's actually not true. Our fee is set as a percentage. And in fact, as plaintiffs, we make more money the quicker it gets done. And that's one of the reasons the judge has started to kick back on some of these deadlines, because as plaintiffs, we've been complaining things have been moving too slow. We're trying to push it forward. And now the judge is like, well, if you're pushing everything forward, don't be asking for extra time for your people to get stuff done. So on a plaintiff side, like, then this is kind of true across the board. As plaintiffs, we always want the case to move fast. Delay favors the defense. It's rule of thumb. So anyone who thinks like as plaintiff attorneys, we're trying to slow this down, I can understand why you might be skeptical, but you don't understand the motivations here. It does us no good to slow things down. The quicker we get this forward, the quicker we get paid, the quicker you get paid, and the quicker everyone can resolve this.
Yeah, and just to expound on that, we don't get paid on time. We don't bill our time. We don't get paid hourly. We get paid by results. The quicker we get the results, the quicker we get our money and your money.
So, the deadline tightening and lack of grace period with the census obligations, kind of the biggest thing you need to take away from this. If someone reaches out to you, turn it around, get us our stuff back quick. If for some reason you can't get it back to us quick, reach out, let us know. Do not ignore the communication. Some things that are happening is, let's say we send out a census, the defense then, gets some records, and in the records they say, well, hey, we found this other doctor mentioned. There's a deficiency here. So what will happen? We send the census out, we get notice of the deficiency, we have to investigate to see if it's really a deficiency. Once we determine it is, we ask you for the updated information. So biggest thing we're doing right now, aside from the discovery process itself. Yeah, and really, from an update standpoint, that's most of what we have to tell you guys that's changed. It's kind of a boring phase of the litigation, and it'll be that way, probably for the next few months. And in that the judge, we have these monthly hearings in front of the judge where we go over everything. And in fact, next month's was canceled by the judge. So I'll probably have even less to update you with in the May town hall. Let's see. Question on the census information is incorrect. Trying to get it fixed. Sign it anyway. Send an email to us and let us know, because we can change it after it's been submitted. So we can amend it, but we have to get it in by the deadline. If you miss the deadline, you're kind of like in a bad situation. We may not be able to resurrect that. And we get some stuff. If you will know if the ball's in your court, right? If you're checking your information, you're checking your emails, watching your phone messages, if the ball's in your court, you will know it. We've got a team of people that are reaching out to you because, bells, whistles, flags, everything's going off at our office if something's delayed or something's not getting back. So, you are not going to have to wonder if you have kept us updated with contact information. That's your obligation. Remember, as a client, if your contact information changes, you have to tell us. But as long as we've got your current information, we are reaching out to you if we need anything. So you won't have to wonder. And if you didn't get a notice of a deficiency on your census, that probably means they've either not got a chance to review it yet and look at it, or if they did look at it, they didn't notice anything wrong with it and it's fine. So it's only the deficiencies right now that we'd be cleaning up for people who've already submitted some censuses. I know we're 10, 12 minutes in. Anthony, can you think of anything else we need to add on this?
Not for this particular meeting. We covered everything. It is, like Stan said, it's kind of a little bit of a lull. I'll tell the story is, I grew up in my dad being in the wine business. And this kind of reminds me, what we do reminds me of it sometimes, where you run around in the beginning and you plant the grapes and you get them all going. And then you sit around and you wait for them to grow. And you watch them grow, and it takes a lot of time. It's a very slow process. And then when they're ready to grow, you run around like crazy. When they're finished growing, you pull them all off and you put them into the vat to get them made. So it's kind of like hurry up, wait, and then hurry up again. That's kind of how the life of these cases go. Wouldn't you agree with that, Stan?
Yeah, it is. It's, hurry up, do your thing, and then wait for the other side. Hurry up, do your thing, then wait for the other side. But when the ball's in our court, we've got to move because as plaintiffs, we try to push it, and we, everything we do that delays the case gives the defense an excuse to be slow also. If we've got this extra time, I guess we could open it up for an extended question phase if people have more questions that we, sometimes can't get to because we have a somewhat abbreviated question and answer session. And I see I'm getting messages from staff here that we probably need to take a break so we can start to organize some of these questions. Anything? God, I feel like I must be leaving stuff out, but really, in the litigation, it's the discovery phase, right? Getting documents and looking at them and, gathering information from our clients. I can't think of much else we have to share at this point. Can you, Anthony?
No, I think we've covered the most important thing, like we said, is be available for those deficiencies because, as Stan said, the judge is not as forgiving as he was in the beginning of the litigation, and a lot of the reason is because we have been pushing at every single one of those hearings. Stan is up there with the rest of the committee that's on there, and they're pushing, hey, we want our case moved. We want our plaintiffs, satisfied. We want to get our people their money, and we want resolution to this case. So we want to move it faster and faster. And the judge said, okay, be careful what you wish for. We're going to move it fast now. We're not going to give you as much time, and there's going to be less reason for excuses if you want to move fast. So we have to step up now and make sure that we produce when we say we're gonna, because we need these, we need the case to move. So these census deficiencies, if we get in touch with you, please turn it around as fast as possible. In the life of this case, this is probably one of the most important things you're going to have to do at this point.
All right, well said, Anthony. So why don't we take 5 minutes at this point? We'll hop off. We'll gather some of the questions together that have been asked so far. And if anyone's got other questions, we have a little extra time today, so maybe we'll try to jump into as many of those as we can get to.
Dolman Russo LLP welcomes you to this Suboxone Town Hall. Please know, this is a live public event. Participation does not create an attorney-client relationship, and it does not establish attorney-client privilege. The information discussed here is for general informational purposes only, and should not be considered legal advice. Please do not share sensitive or personal health information in the live chat. Questions related to individual health conditions or unrelated personal legal matters will not be answered due to privacy concerns. This event is being live streamed and recorded, subject to our privacy policy, which is linked in the video description. The recording may be publicly available after the event. If you do not wish for your name, username, or profile image, which may appear next to your username depending on your Google account settings, to be associated with this video in perpetuity without further compensation or review, please do not participate in the live chat or comment section, as these are publicly visible and may appear in the recording. This event will be starting soon. Thank you.
All right, guys, we're back. It looks like we got a list of questions that have come in. Some of them come in, repeatedly, so we get some of those. We got one question. Is everyone required to participate in a census, or are individuals randomly selected? Okay, so there are 3 states that are not diversity states, and this could get into a deep conversation about legal issues, but New Jersey, Virginia, Delaware. Right? If you're a member of one of those 3 states, or your case is out of one of those 3 states, we would still need all your information, but you are not going to fill out an official census. Other than that, everyone will be filling out a census. It is possible that you may not have been contacted yet for your census. Keep an eye on your email, your text, your phone. The census window for us getting them completed is going to be June 1st. So we're going to be getting all of them done and back by June 1st. But then after that, there's still a 60-day window where the defense can say there's a problem with the census and need us to give them more answers, need an amendment. So it's probably until July 31st, the end of July, when you're finally going to be able to relax and say, hey, I don't need to watch for emails about a potential census issue in my email. But till July 31st, everyone needs to monitor whether or not you've completed one.
Is it possible for things
Go
to
ahead.
move faster than expected? It's possible. We don't know. Once we start getting these censuses in, things could move quicker. But right now, the timelines we're giving you are pretty accurate, and you should probably hang your hat on those and expect those to be the timelines. I don't think it's going to be any longer, but it could be shorter. But for the purposes of what we're outlining, giving you the 30,000-foot view, I think the timeframes that we're putting out there in these census in these town hall meetings every month is pretty, and our newsletters is pretty accurate and pretty much the way it's going to be going.
Yeah, and then I see a question about if someone's getting some implants, things are changing, and did the questioning whether or not they should ask the doctor to send the records directly or whether that person should do them themselves. Look, you can ask the doctor to do it directly. Please go ahead and send them yourself, though, just to be sure. That it's not going to be as important to the doctor's office as it is to you. So always go ahead and do that yourself, but you can ask the doctor to do it as well.
If we have further loss of teeth during the waiting period after we've signed our census, should we continue to submit those to you for updates? Absolutely. Anything that changes, any additional medical treatment, any additional records, anything that changes in your life, address, phone number, circumstances of your life, we need to know about it. Send it to us, give it to your agent that's speaking to you, send an email, a text, a fax, anything to get that information to us. But we want to know everything that we possibly need to know about you, because that's the only way we're going to be able to move your case forward.
Yeah, and then I see some questions about bellwether trials. Do they always go to trial? Yeah, the short answer, I mean, nothing is 100% always, but the short answer is yes. If it's a bellwether, you're not going to expect it to settle pre-suit, because the whole purpose of the bellwether is to get the verdict so we have an idea of what juries think about these trials. Pre-suit settlement does not accomplish the purpose of a bellwether. So does that mean it's illegal for the defense to pull money out and settle a bellwether claim? No, they can do whatever they want, right? And people are able to accept settlement offers if they're made. But the practical answer to it is no. It would be very unlikely that the bellwether would settle it and rather than go to trial. And then I see some, I'll take the next one too, about damages. Unfortunately, some people have passed away during this litigation. It's not just one person. We've had this on a number of cases. And it is unfortunate because Suboxone may play a role in their unfortunate passing. In this case, we are solely working on dental issues related to Suboxone use. It's got to do with the warnings that were on the label, who was told what and when, to the extent there may have been another issue with the drug that contributed to someone's death. Those a lot of times are dealt with in the warnings that were on the label already. So our cases are strictly related to the teeth.
Yeah, someone's saying that they've just returned to this chat, and from what they're reading, it's going to be a few more years before we know anything regarding settlement or funding. Unfortunately, yes, as we said a little earlier, it looks like the bellwethers will not start until sometime in the third quarter, meaning the fall of next year, 2027. So it is highly likely that no settlements will be reached until after at least a couple of the bellwethers have gone, have been tried from start to finish. So yes, right now we're looking at a timeline of at least another year and a half to almost 2 years before there's any kind of a discernible resolution to the case.
And, we've got some questions about what will happen if your case is essentially chosen as a bellwether and you go to trial. Yeah, you may be required to show up at court. That would be something we would arrange and deal with on a case-by-case basis. Very unlikely for any given person. So don't really think about that. Maybe a 1 in 5,000 chance that you would be that person, but very, very unlikely that any one person is going to be a bellwether. Oh, yeah. Yeah, so, and you would have been notified already if you were in the current bellwether pool.
What happens if the doctor or pharmacy that prescribed the Suboxone or the dentist who did the work are no longer in practice? That's a little bit of an issue for us. We've been having to track down a lot of the medical records, and that's caused some delays in it. We're doing our best to, find out if we can get the records. There's also affidavits that we've asked some people to sign so that we can get that information as to, what they were treated with, how they were treated. But it's a difficulty, and it's part of the litigation when you have this many people and, going back that many years. Sometimes there are difficulties in receiving or getting the records or the information we need. And that's just something that we just need as much cooperation from whoever's, helping us with it. We need as much cooperation from you, the clients, to give us the information as best as possible. And we're doing our best to give a full picture of your case in the census.
Yeah, essentially, the records are the best evidence of what happened to you, right? We need to be able to submit the records to prove you took the drug. If for some reason the records were destroyed, right? Like, hey, your pharmacy burned down. The doctor's office got closed, some of these things, then there are ways we could address that through declarations. If that's happening in your case, we've sent out requests for records and got hey, this place burned down, something like that, we would be reaching out to you. So if there's a declaration that's applicable to your case, we're already on top of that, and we'll be reaching out to you about that. And I see someone concerned about not getting calls back right now. We've got about 30 people on a call team. They are right now primarily consumed with getting census information done and back. So it is possible that they're getting a little overwhelmed and you may not be getting a call back. I would apologize for that. But what I would tell you, do not rely just on calls. Please email, text, written communication is going to sit there and it will get responded to. It will not get ignored. So if for some reason you don't feel like you're getting your call back, do not hesitate. Do not wait for the call back. Email us, text us. I apologize if that's happening to you, but don't just rely on calling.
And just to expound on it, if you are calling to ask a question or to, give us information, we appreciate that. Keep trying. But if we need you for something important, that's a time sensitive, a deadline, we're going to reach out and find you. We're going to get to you. So if you're not getting a call back right now, it's more likely than not that you're in compliance with everything we need and that we're working on somebody else's deadline, or, while we're working on your deadline, someone else may not be getting a call back on just an ancillary, non-time sensitive question. But like Stan said, keep trying. We will get back to you. But the most important thing for us to do is to work on getting everyone's census compliant and done in a timely manner, like we spoke about before. It's very important because there isn't a lot of flexibility. There's not a lot of forgiveness by the judge on the time frames. So our first and foremost priority is to make sure we're complying with the deadlines and getting everybody's censuses in and information in a timely manner. So we have to prioritize, questions or things that aren't as time sensitive. But we will get back to you. Stan, there's some questions about the type of compensations that people are entitled
Yes.
to. You want to talk about that?
Yeah, I'll tee that up. So really, the type of compensations we're getting questioned about are what we call non-economic damages, right? Your economic damages will be wage loss, right? We know how much you lost in wages. Medical bills, we know how much your medical bills are. Future medical bills, we got doctors saying how much it'll cost in the future, right? Non-economic damages are those damages that don't come with a price tag already attached. Pain, suffering, mental anguish, embarrassment, loss of ability to enjoy life, those types of things. Are they an element of this claim? Absolutely. Are they recognized? Yes. And this kind of leads into another question. Settlement, right? How is it recognized? Everything we do is about getting money. At the end of the day, if this settles, there's going to be a settlement matrix. And all those factors which the court has determined are relevant in determining the value of your claim are on that settlement matrix. So we would put your information in that settlement matrix and it'll kind of spit out how much of the settlement money you're entitled to. Can I promise you what's going to be on that? No, right? As attorneys, we cannot make promises, right? It's hard. But I would be shocked, right, if the number of teeth lost due to Suboxone wasn't one of those things right at the top. right? So if you're asking, will I get more money if I've got more significant damage? The answer should be yes, right? It only makes common sense that when those settlement matrices are developed, the level of damage and tooth loss that you've got would be commensurate with the compensation you're going to get. It's not going to be the only thing on there, so there will be other things. I can't tell you what all will be on this particular settlement matrix, but the general rule is the more significant your damage and the more significant your loss due to the Suboxone, the more significant your recovery should be. I just can't tell you exactly which factors and how much those are going to weigh in at this time.
And just to expound on that a little bit is that, there's tens of thousands of clients out there, and the settlement matrix is something that's just put in as a formula, and it does make mistakes. Sometimes people are on the cusp between two different matrices, or sometimes they just make a mistake. So if by some chance, when we get to that point, and we'll discuss that again when we're getting much closer to settlement, but if you're not satisfied, or it's very clear that the injury is in a different matrix and they spit out a certain settlement for you, there will be a time period where we can contest those and see if they can go ahead and put you into a different settlement or appeal it. And sometimes they're successful, sometimes they're not. So it's not a perfect science. It's pretty good. That's why they use it. But not every single injury fits perfectly into a matrix. So a lot of that, may be determined later on.
Now, I know we've got some questions about, hey, if I need to get teeth right now, can I get them and ask the doctor to bill to the claim or something like that? I mean, yes, you can ask the doctor to do it. I would be shocked if the doctor will do it. That's treating on what's known as a letter of protection. A letter of protection is just basically a letter that's issued to a doctor that says, hey, if you treat this person in the event there's a settlement, you will get paid out of the settlement before the patient does, or the plaintiff. I haven't seen a dentist yet that's accepting those, especially not in this case. It's usually specialized doctors, more spine, shoulder, orthopedic, that you see in auto accidents. But I can't tell you 100% no one would ever do it, but I would be shocked if you found a doctor or dentist that was willing to give you implants on a letter of protection in this case.
Yeah, unfortunately. If we use government-funded insurance, will they get paid first? That sounds like a question about a lien. If you have insurance, especially government insurance, Medicare, Medicaid, or Social Security, or something along those lines, if they are paying for anything, they are first in line to get paid back. We can negotiate that sometimes and ask them for a little, to take a little less or a fraction of it. There's no guarantees. But yes, they will be in line, and they'll be in line first before anybody else to get paid back.
Well, and I'll kind of add, it's a little bit unclear the way people are asking that question. To the extent you used insurance to pay for care related to this claim, it has a direct lien on the claim for everything it's paid. There are also some insurance and some social benefit policies, right, where programs like government will come out, pay some of your bills and stuff like that. A lot of times when you sign up for those policies and bill payments and stuff, you don't realize that you're signing an assignment of any future claim you may have. So to the extent anyone has signed something like that, if the recipient makes us aware of it, we have to honor it. So, there's going to be liens for people that have paid for care directly related to the case. And we're going to find out about that because, hey, they're going to be noted on the bill for this case. You may have some other type of lien that would have a claim to these funds, right? Well, those we have to honor if we know about them. Right? It's not like we go out and know where to look for every possible lien, but yes, to the extent there is a lien out there, if we're put on notice of it, we got to honor it.
Just to expand that a little more, with our experience, having done several of these type of settlements, mass settlements through a settlement administrator, which is most likely what's going to happen. Unfortunately, they will do the search. To whoever is the company that's going to be handling the settlements. And the way it works is if there is a settlement administrator, they will take hold of the funds and they will release them after they do lien checks and do all the math and make sure it's properly done. They may find a lien if you have a common name, or sometimes they just may misplace a lien and put a lien on something and hold your money. That will take up a lot of time, and it will be a headache, and it will be very frustrating. We hope it doesn't happen to you, but if it does, understand it could happen, and they may put a lien on for Medicare or Medicaid, and you may say, I've never had Medicare or Medicaid in my life. Why are they holding, thousands of dollars of my money? Eventually it will get taken care of, but those things do take a long time, and it is very unfortunate if it happens to you. Just remember now, we'll remind you again, we hope it doesn't happen to you, but that could very well happen because they'll do the lien searches themselves, and it's not a perfect science.
So it looks like we got some questions about reaching out to speak to the defense directly. It's not a good idea, right? Don't do it. They're not going to speak to you. We've had a few people that do it, and we essentially get calls like, hey, come get your dog out of my yard. Why is this person contacting me? Control your client. So yes, it's look, I can't stop anyone from doing anything, right? I don't control people's phones. You do it, they're not going to talk to you. They're not allowed to talk to you. And really they call us and say, you got a client who doesn't understand the process here. Please get control of them.
Someone is asking,
can you take out loans on, go ahead.
Sorry.
Loans on settlements.
If the lawyers come on and talk, Stan, myself, and Matt Dolman are the lawyers handling your case. We're the ones at the forefront of it. Stan is on the committee. He's at the meetings all the time. So yes, this is us on these broadcasts talking directly to you all and answering your questions. Some of our staff members are behind the scenes helping us, basically fielding the questions and giving them to us, and also making sure that an old guy like me and a less older guy, but an old guy like Stan are able to get on and make sure the technology is available for you guys. But yes, we are the lawyers.
Kind of makes me wonder who the hell this person thought we were. Can we take loans out on settlements? The short answer is it's kind of like this. Technically, yeah, you're allowed to take loans out on settlements. The practical answer is nobody's loaning money on these settlements, right? There's certain companies that do these types of pre-settlement loans and stuff like that. This is not the claim that's in the wheelhouse where they're underwriting them yet. There may come a time where these cases reach a point where you could get some settlement funding. It's going to be way down the road. And we'll probably let you know, you'll probably be getting contacted by people because they'll be able to find out your name because it'll be public records and you filed suit, and they'll be reaching, hey, want to loan you money on your case, reach out to us. But right now we probably had 100, 200 people inquire. Nobody's loaning money on the cases.
Someone's asking about going to Turkey to get implants. All the cases going on, will all that cost be reimbursed with the pain and suffering element also? Unfortunately, there's no reimbursement per se. You're going to receive a settlement based on what the bellwether trials say and how we can negotiate with the defendants. And everyone's going to be put in a matrix. There's going to be settlements doled out, and we're hoping those can cover some, if not all of your medical, whatever medical treatment you're getting. It's not going to be a dollar for dollar reimbursement. It's going to be as much as they say, the settlements are going to be, which may or may not cover it. But we encourage you, obviously, if you are in pain or you're suffering, to go out and get yourself fixed up as fast as possible. And hopefully whatever the settlements are, we'll at least, pay some of that back or maybe all of it.
And then the money you owe in judgments also get paid first. Don't really know how to quite answer that. To the extent someone's got a lien or a claim against you, if we're made aware of it, we have to deal with it. It's kind of that simple. So I don't know what kind of judgment or money you're talking about, but to the extent someone puts us on notice of a lien or claim against you, as attorneys, we can't ignore that. So we got to deal with it. I see some questions about problems with veins in their legs. That's not anything we'd be dealing with in this particular case. We're solely related to dental issues.
Someone back a couple of questions back asked, they might have been on here late, if we think there's a possible resolution likely in the next 2 years. That's right about when we're thinking some of these bellwethers are going to be done, and it's possible there could be, some kind of settlements in that time frame. The unfortunate and the realistic reality of it, having been through this, several of these that we've now administered and settled, unfortunately, it's going to be quite a bit of time between the settlement and when the actual payments come out. So let's say, for argument's sake, the case settled tomorrow. It might be a whole nother year before the money comes out through the settlement, unfortunately, because there's so many claims to process and it takes so long. So, when we're talking about settlements and we're talking about time frame, there's a time frame to settlement and there's also time frame to getting paid. So we'll get into that more as we get closer, but I just want everyone to kind of digest that now at this point and understand that settlement, the time of settlement doesn't mean you're going to get paid relatively quickly. There might be another period of time where, a significant period of time before the payments come out, unfortunately.
I see a question about, do you communicate with us by email? Yes. And it says, if so, how do I know you have my current email address? I'm going to assume that's how you knew the town hall was tonight, because we would have sent out the notice to your email. So if you got the notice at your email, I have to assume we've got your email address. There's another question about here. Hey, my phone kicks back unrecognized numbers. I don't want to miss the call. We'll change the setting on your phone. I don't really know how to fix that. If you've got your phone set to where it's going to kick out a number that comes from us, we don't have a workaround for that. That's going to be a setting on your phone you're going to have to adjust.
Our staff is telling us, though, that the email is on screen for you to contact us directly to make sure we have your proper email. So if you are in any doubt, make sure you give us your most current email and phone number. And again, like we say at every one of these meetings, as much information to get in touch with us, somebody emergency contact, whatever it is, because when we need you, we're going to reach out to you. And unfortunately, we don't set the time frames. The court does. So if we need to get in touch with you in an emergency, we really need to make sure on a timely basis we can get back in touch with us.
I know some people look like they may say they're uncomfortable with our abilities. Maybe we're not inspiring confidence, don't know what we would have done to do that. But I remind you that there's no requirement that you stay with us. If you feel like you've got another more competent attorney that's in a better position to represent you, you are free to go work with them. So I don't know what else to do, but yeah, that's it. You got two people right here. I'm on the steering committee, but if for some reason I'm not inspiring confidence, you're free to go wherever you'd like.
Yes, and just to reiterate on that, I've been doing this type of work for 30 plus years now. Been on several steering committees and been from start to finish, as has a lot of our staff with us, been through start and finish to several of these type of cases. So we understand them very well, and we know how they go from start to finish, and we're just trying to be as honest with you all as possible. Somebody else may tell you something different, but we're being as honest as possible and trying to prepare you for the reality of it. And hopefully, if you don't like what we're saying, hopefully you still believe that we're being honest with you. And that's something we're gonna continue to do.
And we have had a few people pass away during this litigation, and we got a question about that, like declaring a beneficiary. Yeah, yes, you can declare a beneficiary. The bigger thing is, right, if you pass away, the plaintiff in the case becomes your estate. So your estate will stand in your shoes and would settle the claim on your behalf, and then the money would be processed through your estate after settlement. But it doesn't go away. The claim doesn't end, but an estate has to be open in order for us to bring the claim. It's like after you're dead, it's just like before you're born, right? You're not a person. So before you're born, I can't sue on your behalf. You can't be charged with a crime for the most part, right? And then after you're dead, you're not recognized as a person. So I would need an estate to have an entity to bring a case on behalf of. And we do
And
that on cases on a
unfortunately,
regular basis.
yeah, unfortunately, we do that. That happens quite often with the amount of people that are in these types of settlements. But unfortunately, the costs of setting up that estate come directly out of the settlement. But it's a necessary evil. It has to happen, and whoever is your beneficiary will still receive the proceeds from your settlement, just maybe less some of the court costs and setup fees.
And then I got it's a question about the census. I received my census today and it's not showing everything. Should I still sign it and call you to figure it out? Yes, is the answer, but also email us with the changes that you feel like you need to make after you sign. So sign it, send it. Follow up with an email and get us, the written version of what you believe needs to be changed and call, right? We can never be too cautious with this. So any one of those should be good. Let's do all three to make sure nothing gets missed.
And just to remind you guys and reiterate, it's so important that we're in the period of the census and then deficiencies. The message today, really most importantly, is if you are contacted for your census, for things that are missing on your census or for a possible deficiency, please make sure you get back to us because it's very, very important that we submit everything in a timely manner. So when we reach out to you, it may be a much shorter window than the 30 days, but please make sure you get back to us so we can get your claim in and any deficiencies corrected in a timely manner.
And then the question, is there a paper trail proving they knew? All I can tell you is there's a bunch of paper. I can't tell you what's in the paper, what the paper shows, or what we intend on proving with it yet. I wish I could.
But there will be a day where you can.
Yes. Everything will come to light in time. It's just now is not that time. And then how important are voluntary impact statements? If I'm to be honest, not very. We will ask for them if we need them. Some people feel like they've been through an extraordinary situation that needs to be shared and we need to know about it. And by all means, if that's you, let us know. That being said, these are not going to be super important at this point in either establishing liability or the value of your claim.
They're important. They to you, maybe they might be important. And by all means, please send them in because it'll help us understand who you are, but unfortunately, they're not going to do much for your case. They're not going to hurt your case, but they're probably not going to help your case. But like I said, if it's something that is cathartic for you or helpful to you to explain your story so we know you better as a person, by all means, please send it in. We're here to help.
Yeah, I don't want to minimize it or anything, but it's like someone who lost 3 teeth, like you lost 3 teeth, someone else lost 3 teeth. If you had a stronger emotional damage or emotional response, that's certainly going to be recognized, but I doubt it's going to be recognized to the level of the initial impact of the tooth loss, right? So how it plays out on a settlement matrix still to be seen. We want to see it, but I think the more important stuff for us to get is make sure we got the records on proof of use and the physical damage. And yes, you still can give an impact statement. Absolutely. If you give one, it's added to your file. And if we can ever use it to help add value to your case, we will. So what is this? How many cases you've done like this? How many? Okay. We do lots of cases like this. How many have resulted in settlements for your clients? Often is a case like this flat out lost or dismissed. It happens. I don't think, look, my crystal ball is not 100% clear. Like if we knew what was going to happen with cases and what judges and juries were going to do, there'd be no reason to have the trials, right? So we're all kind of guessing. There is what's known as a 𝗣𝗟𝗘𝗔𝗦𝗘 hearing, right? In this case, we're saying, acid causes enamel erosion on teeth. Right, that's a pretty straightforward chemical reaction, a pretty straightforward causation analysis. We were also involved in some of the litigation regarding Tylenol causing autism. Those cases initially got bounced at the 𝗣𝗟𝗘𝗔𝗦𝗘 hearing because the judge said that the the science wasn't strong enough. So in cases like this, what we would look at is they're either probably all going to settle or all going to go down together. I feel pretty strongly about the science in this case, and sort of a secondary sort of support to that is this is a case where the FDA came back and made them put the warning on the product. Right. So that's something that helps us, right? If it didn't cause enamel erosion, why would the FDA make them warn about it? Now, question is when they knew and should have known, when should they have started warning people? They shouldn't have waited for the FDA to force them, but that's kind of where it's at.
What's a potential deficiency, Stan? What's an example of a deficiency?
Deficiency may be you sent your census. You said I got drugs, or I got my Suboxone from CVS, right? They get the CVS records, and in addition to the doctor you disclosed on your census, they find 3 other doctors, right, that we didn't tell them about. Well, your census was deficient because there are more medical providers than you told them about. So it would be something when they kind of deal with the first stuff we send in, things they realize, hey, this doesn't look complete. Look, we found something that indicates something's missing.
Difference between Dolman Russo, the Russo Firm, and Dolman Law. Okay, Dolman Law is Stan, Gipe, and Matt Dolman. That's their law firm. The Russo Firm is myself and my lawyers that work on my firm. Dolman Russo is the firm we have put together with all of us, all the lawyers in my firm, all the lawyers in Stan and Matt's firm that now are handling, and all our staffs that are jointly together, created a special law firm just to handle your Suboxone cases. So you have double or triple the amount of lawyers, double or triple the amount of staff, and double or triple the amount of expenses and the ability to, war chest per se, to go ahead and spend money and prosecute your cases. So that's what we've done together just for the purpose of this particular claim, that we've put this whole big firm together.
Yeah, and just so you know, this stuff isn't cheap, so it does takes other firms. We all contribute to, what's been a 7-figure fund that we've used to move these cases forward. So when you realize the size of the companies we're fighting against and the resources we put at, it takes a lot, and it's not just one firm. It's going to be a conglomerate of firms that put up money to fight these things.
Yeah, and every single case involves medical records, which may be as little as $100 or $200, but also maybe several $100s or maybe even $1,000 or more to get those records. Additionally, every single case that had to be filed, which are most of them, required a $419 filing fee. So, if we have, 10,000 clients in our particular, kitty that we're representing, it's 10,000 or however many clients we have times all the medical records we had to order or all the filings we had to do. And that money goes paid up front by us out of our pockets, in the hopes that we're going to be able to settle this claim at some point, get our money we put out back, and of course, get the clients their money and hopefully get some fees for us too. So our time and the years we've spent on this will be able to realize a fee, but more importantly, be able to get our clients the satisfaction that they need.
It says, and I guess someone asked why we need a group of firm to do these cases. Is because Indivior, the companies we're fighting, they're billion-dollar companies. They've got teams of attorneys fighting this on the other side, right? So when you've got thousands of clients, it takes groups of people to move these together and fight. and it takes a lot of money. I don't think people realize the amount of money that goes into moving these and getting the discovery and getting the experts and the hours. It takes millions and millions of dollars to even get to the point where we get a bellwether. And half the time we crap out and you end up with nothing. I don't want to say half the time. Sometimes you crap out and end up with nothing. But it's a lot of money and it's a lot of risk. And every single multi-district litigation, what some people call class action, even though these are a little different, every single one of them is handled by a conglomerate of firms that are required to put up money together to bring these claims. That's what's known as a steering committee. And that's why the courts recognize that, and they put together the steering committee on the front end and say, these are the firms that have demonstrated a commitment, a willingness, and an ability to fund and fight this case.
And the firms that are chosen for the steering committee usually have experience in having done this before, because you have to apply. You actually have to apply, and a lot of people do apply. A lot of people are turned down, and the judge chooses what he thinks is the best committee to represent the plaintiffs here, the most experienced ones, the ones who have done it before, who can demonstrate that they have not only the financial means to wage this war throughout the whole couple of years it's going to take, but also the staff and the ability to do the work that it takes to prosecute this case over the next several years. Stan, are we taking any new cases?
If it's already been filed and someone needed to transfer representation, we might. I think, and I'd have to double check on this, but I think we're outside SOL now on just about everything, aren't we? So I think I don't want to say no, but it would be very few and far between that we'd be taking new cases now.
Yeah, I think as Stan said, we're getting the feedback that almost all the statutes have passed. We're not taking any new fresh cases, unfortunately, and that's not us as much as it's the court determining there has to be a cutoff somewhere, and they've ascertained what the cutoff is. So we're not going to be taking any new fresh cases. But like Stan said, if there was extenuating circumstances where somebody had already been filed, they're with another firm, they maybe feel like they're not getting the representation that they feel they can get better here, we would certainly entertain taking that case on. But for the most part, I guess the answer would be no, we're not taking any new cases.
All right. Well, I think we've kind of rolled into 8 o'clock, and we'll kind of start wrapping things up now. And, to the extent you guys joined us, thank you. To the extent you want to join next month, we would love to have you on. Think about your questions, right? Anything that comes up during the month, during the week, write it down. You'll have an opportunity to be at the next town hall. Ask us again. Always happy to do this. I feel like it's better for us to have more touch points with our clients than not. And we want you guys to feel like you're included in the process, even when there's not really not a lot to tell you. We still want to let you know what's going on. So we appreciate you logging on. We know you got better things to do with your time than just sit there and listen to us. So I do appreciate you taking the time out to join us here today.
Yeah, thank you very much. Again, it's our honor to represent you on behalf of Stan, myself, Matt, who's not here, and our entire staff who we could not do this without. We thank you again for having the confidence in us.
All right, guys, thanks. And until next month, it's been a pleasure representing you from everyone here at Dolman Russo.